And we are joined now in studio by the Foundation's Anton van Dalsen. Anton, it's good to have you with us.
Morning.
Why have you decided to add your voice to a call that I suppose the Democratic Alliance has already made in Parliament? And this is the reason why I suppose also Parliament was sitting yesterday to try and determine regulation on how you remove a public protector from office, not only a public protector, but all other Chapter 9 heads.
Indeed. I think let's start with the fact that the public protector plays a very important role within the South African Constitution. A number of recent court cases have shown that the current incumbent has acted unlawfully, in bad faith, gross unreasonableness, does not understand her role within the Constitution. And we and a number of other civil society organizations have felt that we should make our voices heard and to underline the fact that someone who fills this very important position but is unable to do that in a lawful manner causes great damage to South African society.
How do you propose that be done in the midst of challenges currently on those reports that are being taken under judicial review and of course the public protector herself maintaining that there's nothing untoward? It's part of the process. It's part of the legal remedy that is available to everyone to take my reports on review, not to agree with them, and to have them overturned. It's not only happened to me, but in fact, a large number of the judgments that have been overturned are from the previous public protector.
Yes, I think don't even want to go into the ones that are still before the courts. Those are not relevant for current purposes. So we are not prejudging courts. And if we look at the most important judgment, which was made by the Constitutional Court a few weeks ago, and there is no further appeal from the Constitutional Court. And the Constitutional Court found in the case where the public protector was involved with the Reserve Bank and ABSA that she acted in bad faith, she was grossly unreasonable, she did not understand her constitutional mandate. And that is sufficient, just that one Constitutional Court case, to fill the requirements that the Constitution has for her removal, and that is misconduct, incapacity, or incompetence. So purely looking at that Constitutional Court judgment, the grounds for her removal are there very plainly. There is no doubt about it. Yeah. And the feeling amongst these civil society organizations is that Parliament must now act in following that Constitutional Court judgment.
There have been some in opposition parties who have been calling on civil society organizations, even calling on others within the ruling party to stop insulting, so to speak, the public protector and to respect that office of the public protector. Lots of comments have been said directed at the public protector, which really brings her credibility into question. What is the view of civil society on some of that?
In the current initiative, we're not even looking at the motives behind what she has been doing. There's been a lot of speculation about that in the press. We are acting purely on the basis of the Constitutional Court judgment, which incidentally ordered her to pay 15% of the costs out of her own pocket. Now, this is almost never done by courts, and this underlines the seriousness with which the court viewed her conduct. It's seen as a last resort by the courts to make their dissatisfaction clear when people who hold public office act in an unreasonable and unlawful way.
How do you separate the incumbent, Busisiwe Mkhwebane, in that office and the protection of the Chapter 9 institution itself, being the public protector?
You mean as far as the process is concerned?
As far as going forward,
yeah.
Because argument is that we are setting ourselves up for a disaster going forward because we might be attacking the Chapter 9 institution, the office of the public protector, because of the behavior of the incumbent, and the what will result from these court processes is that in the future, we'll find that this particular office, for example, will have no teeth. Issues like cost orders that have been issued against her, those who are arguing, saying this is going to be problematic for us going forward because the public protector won't be able to do her work because she will fear these cost orders.
No, I think that's a complete and utter misapprehension. The fact is, if the public protector acts in a lawful way, then the courts will make no cost orders against her. But if the public protector acts in a way which is unlawful, where bad faith, dishonesty, gross unreasonableness are concerned, then they will get cost orders against them. It's quite clear. So if a public protector or anybody who fulfills a position in terms of the Constitution acts in a lawful and a reasonable way, they can make mistakes, but that's not the problem. As long as it's lawful and reasonable, then there will be no cost orders. So I think this issue, the cost orders, purely underlines the extent to which the current public protector has contravened or has gone beyond the limits of our office.
So what is the process then that is to be followed now as far as regulations are concerned?
The Constitution makes provision for the removal process of a public protector on the grounds of misconduct, incapacity or incompetence. That then has to go through the relevant portfolio committee within Parliament, and which then, and after that, has to be voted on by Parliament or by the National Assembly, where 2/3 majority is required. So the next step is for it to be considered by a parliamentary committee. And yesterday, the Portfolio Committee on Justice referred the whole matter to the Rules Committee to ensure that the proper procedure is followed within Parliament.
Now, how do we prevent ourselves from getting in this point again? Let's say we do remove this public protector. Now, there was a public process of the appointment of the public protector. You participated in it, if I'm not mistaken.
We didn't participate in it, but I'm aware of the public process. Yeah.
How do we then ensure that we don't get to this point again?
I think the major issue is whatever qualifications a person may have, a greater focus must be put on the experience of the person, the integrity of the person, because all of these things, you cannot legislate for integrity.
Yeah.
You can say somebody must have a university education, must have been active in law for so many years and so on, but that says nothing about the actual experience and the integrity of the person, and a much greater focus has to be put on these issues.
Anton, much appreciated, and thank you so much for coming through.
Thank you.
That is Anton van Dalsen. He is, of course, from the Helen Suzman Foundation, one of the 10 civil society organizations that have appealed to the Portfolio Committee on Justice and Correctional Services for the Public Protector Busisiwe Mkhwebane to be removed from her position.